The media represents an important stakeholder for the judiciary. It is through the media that our stories are told, what is happening within the judiciary, what is working and what is not. The media also represents the means through which we are held accountable as a judiciary to the people of Jamaica, accepting that we provide an essential service to each and every Jamaican citizen.
Fairness, independence, accessibility, and accountability are some of the outcomes an efficient and effective justice system seeks to promote. The promotion of these outcomes create positive relationships between the court and court users, which aid in the building of public trust and confidence in all courts. In this regard, therefore, the courts have continued to rely on statistical data as an essential part of its growth and in furtherance of the achievement of these outcomes, all with a view to continue improving. Towards this end, based on an examination of the statistical report on criminal matters in the parish courts of Jamaica for the year ended December 31, 2022, it would be very fair to say that the parish courts have done and continue to do very well, notwithstanding the ever-present infrastructural challenges and resource constraints. For this period under review, the case clearance rate in the parish courts, the criminal divisions, was 124.58%. Basically, this means that for every 100 criminal cases filed in the parish courts, 124 were disposed of on average. As of the year 2022, we discovered that 70% of the cases in the courts were for traffic offenses. And given the recent spotlight that was shone on the court system because of the effort to clear long outstanding traffic matters, I think it's an appropriate point to focus on. Consequently, whilst most are positive, the new system as regards the traffic matters has highlighted several challenges in the court infrastructure as it relates to the prosecution and disposal of traffic offenses. Chief among them are the volume of paperwork in the courts, allocation of space for storage and processing time. While the new electronic ticketing system will assist with reducing the paperwork at the courts, for its full potential to be realized, there will need to be the appropriate amendment to the relevant legislations in order for the courts to work in a fully digital space. Over the past few months, the traffic court has seen an influx of printouts containing outstanding tickets for the said court to address. Although I say the traffic court, I'm also speaking about the other, island-wide when the other judges sit in their traffic jurisdiction. For the period September 2022 to January 31, 2023, approximately 11,491 printouts were submitted to the corporate area traffic court alone. For the period September to December 2022, approximately 950 printouts were submitted to the court. Since the start of 2023, 11,471 printouts were submitted. As at February 1, 2023, the estimated total number of outstanding tickets from the aforementioned printouts was 385,841 tickets. This is inclusive of approximately 579 emails received up to January 31, 2023. As such, certain strategies had to be implemented to address outstanding tickets. Subsequently, a decision was taken to resume night court sittings as well as to introduce Saturday court sittings across the parish courts throughout the island, where necessary, as well as at the corporate area traffic court in an effort to address these outstanding traffic matters. The pilot was the corporate area traffic court, where at the end of December 2022, there were night court and Saturday court sittings for the period December 5, 2022 to December 17, 2022. The said sittings were reconvened on January 9, 2023 to February 4, 2023 at the Corporate Area Traffic Court. However, in an effort to employ a more structured and practical approach to addressing these outstanding tickets, as well as to ease the pressure on the court staff and judges, while simultaneously allowing the court to better serve the court users, night court and Saturday sittings were postponed for a period of three weeks, being February 6th to February 25, 2023. During this period, efforts were made by the traffic court staff, along with the help of some hard trainees, to count the number of printouts received, peruse the said printouts to determine whether the tickets listed on same were within the jurisdiction of the traffic court, sort the various printouts in the following categories: printouts containing 1 to 5 tickets, printouts containing 6 to 10 tickets, and printouts containing 11 or more tickets. Placing the said printouts in respective folders and in date order received, and locating the tickets on the respective printouts. This was with a view to bringing more order to what was initially perceived as a very chaotic situation. In addition, the traffic court received and continues to receive considerable assistance from the Court Administration Division in calling and informing court users of assigned court dates, as well as responding to queries relative to the printouts received. Further, it was noted that despite their best efforts, it would have been impracticable for the limited staff at the traffic court to undertake the search of the almost 400,000 outstanding tickets which were submitted by way of printouts to the court in recent times, so as to bring them before the court to be addressed within a reasonable time frame. As such, steps were taken for the court to embark on a special project with the assistance of the Court Administration Division to engage various persons from courts across the corporate area to assist in the execution of the said task. A number of persons were selected, and they have already commenced carrying out the said task after court hours during the week, as well as on Saturdays, since February 20th, 2023. It is estimated that this project will take approximately 3 months to be completed. A decision was also made to increase the number of judges to sit in both the night and Saturday courts. As such, at the corporate area traffic court, 4 judges, including judges of the traffic courts as well as other judges within the corporate area, are now sitting each night on Saturdays to address the outstanding tickets. The traffic court at the Melbourne location, which is beside Sabina Park, currently has 3 courtrooms, and there's also one at 36 Camp Road. A container was basically retrofitted to serve as a makeshift courtroom in an effort to address in an effort to try and clear the backlog that the staff are dealing with. The traffic court situation, before I continue, let me also commend the efforts of the judges, the staff, for their almost superhuman efforts in in trying to clear the backlog. When it was going down to that deadline, we have had instances where judges and staff were working up to literally the wee hours of the morning. Some actually slept at the court's offices in an effort to assist our court users at all levels in all the parishes. There's a saying that out of every adverse circumstance comes good. If anything was highlighted by this situation is the fact that while the staff have really made good with the little we are working with over the last few years, we do need more resources. We do need to look towards working in a digital landscape, not only to make us more efficient, but also to assist us to better serve our court users. We also need, at least especially in the corporate area, we need a very dedicated traffic court that is user-friendly, not only for the court users and the staff, but also it must be purpose-driven to serve the attorneys who need to use it, members of the public, and of course the court staff. This can also be expanded to the need island-wide for the other courts who, despite several challenges, have risen to the occasion. For instance, in St. Catherine, there are 2 fires there. Nonetheless, St. Catherine did very well in terms of the statistics, in terms of the clearance rate and disposal rate. St. Anne, where one of the courthouses burnt down, and again, let me commend the staff there and the judges and the leadership on the ground. They also did very well in terms of the statistics. Island-wide, there are challenges universal across the parishes. However, I have to commend my fellow judges, the staff, who, in trying circumstances, no pun intended, still rise to the occasion to help us to clear these matters. Our backlog was below 2%, which is actually over the target we had aimed for and well in keeping with international standards. We nonetheless continue and will continue and endeavor to continue serving the Jamaican public to the best of our ability. Happily, we are in dialogue, constant dialogue with the powers that be, and I think it's fair to say that we are all on the same page because we are all here in the same cause, justice and the best service possible to our court users.
The Court of Appeal of Jamaica has in recent times received more publicity than usual, especially with the prosecution now being able to file appeals against decisions which they are not happy. As the highest court, which is based in the island, the Court of Appeal is the last resort in the justice system for most Jamaicans in resolving their disputes. The court is mindful of that position, and the judges and the staff take their responsibility most seriously. The court not only accepts that it must provide the best guidance that it can to the legal profession and to litigants in general, but accepts that it has a duty of accountability to the Jamaican people. We are now celebrating 60 years of existence, having been established on the 5th of August, 1962. We had a week of celebrations in the first week of August last year. And through those last 60 years, we have grown from a cadre of 3 judges to now where we have 13 judges, including the president, and we have a staff of just about 50 persons, including a registrar and deputy registrar. We aim for transparency by giving reasons for our decisions in all appeals. The decisions are put in writing and are available on the court's website, and it is www.courtofappeal.gov.jm. In addition, the court has, since 2015, at first on the initiative of past President Morrison, produced an annual report on its work. The annual report is sent to the Chief Justice, to the Parliament, Minister of Justice, and a number of other stakeholders. It also is available online for viewing on the website. As some of you are aware, the Court of Appeal hears appeals from the decisions in the Supreme Court, in the Parish Court, and we also hear appeals from specific bodies, such as courts martial that the Army has, the General Legal Council, the Public Accountancy Board, and the Legal Real Estate Board. The appeals are generally heard by a panel of 3 judges. Occasionally, we've had cases where the appeals are heard by 5 judges, but essentially it is 3 judges. Since the onset of the pandemic, the court has heard almost all of its cases via the electronic platform. It means that attorneys and their clients are able to have their cases heard without having to travel to Kingston, especially for the rural areas. It results in saving in both time and cost. We are always seeking to improve our circumstances. The technical department of the Court Administration Division has recently significantly increased the court's bandwidth, and so on that level we are performing very well. We are also seeking to improve our performance by creating what is called a differentiated case management system. This system is designed to radically transform our court processes. It will help to reduce delays and eliminate the backlog of cases which has been plaguing the court for some time. Essentially, DCM, which is what we call the differentiated case management system, is a set of principles and techniques that proportionately matches court resources to the various types of cases, depending on the level of complexity. The aim is to achieve greater efficiency in the processing of cases, reducing delays and backlogs, and generally promoting efficiency in the delivery of the service by the court. And the DCM is designed to help the courts in general, but the judiciary in particular, to 1, more efficiently process the cases, 2, reduce the number of adjournments, 3, reduce delays and backlogs, and 4, provide sound, timely judgments and efficient court services to all our people who seek to use the courts. We say that the system provides different paces for different cases. We are in our 2nd term of using this system, and we have had some positive results. We have established stricter standards for single judges of appeal to turn around applications which they have to consider for leave to appeal. And starting last term, we have had special panels hearing one of the categories of cases, the simple expedited appeals. And the important thing about this particular track of simple expedited appeals is that the judges who hear those appeals will more often than not deliver their decision on the same day that the appeal is heard. The result of these initiatives is that we have significantly shortened the time that these cases will spend in the court. We had 3 such sittings of the court last term. In that time, in those sittings, 11 cases were heard. 8 of them were disposed of during the same week of the hearing, and a similar arrangement is set for this term. So far, we have had 11 cases heard and disposed of, and judgments reserved in 2 more. For the cases in this track, the judgments are usually given orally, and they are later reduced to writing, and as I said before, put on the court's website. Oral judgments are usually used when the law is settled and there is no complexity to the case. This type of judgment has 2 beneficial effects. Firstly, it provides a speedy decision to the parties, and secondly, it allows judges to have more time to work on the cases in which they have to do written judgments. The point here is that with the DCM, no case should be in the Court of Appeal beyond 2 years after the receipt of the papers from the trial court. The second major initiative that we have undertaken in pursuing the implementation of efficiency is the creation of the use of the judicial case management system. And Dr. Dennis is the expert in that regard. But it is expected that when this is fully implemented, it will allow attorneys and other people who wish to use the services of the court to file their documents electronically without having to go to the court building. It will also give judges and court staff easier access to documents which form part of the court files. That allows for rapid reproduction of sections of the documents which need to be quoted in producing judgments. This is a major step in achieving a paperless court. We're having some teething pains, ladies and gentlemen, but once we cross that hurdle, we expect that we will be up and running with a much more efficient system. Another initiative of the court is the streamlining of its process by reducing the time allotted for oral arguments in court. That means people like Mrs. Jackson Miller will have less time to address the court. We're using more endorsements and memoranda of reasons instead of written judgments. We're using standard templates for outlining the law where that law is well established. And the whole idea is to shorten the judgments so that they can be produced more quickly. Starting next term, we will also be including keywords or catchwords in our judgments to aid researchers in finding the cases which deal with their particular issue. I must say that with the significant assistance of the chief court reporter, she recently resigned, but she and her team provided great help in clearing the backlog of the oldest cases in which transcripts were outstanding. In the last year, we have had over 63 transcripts produced and received by the court, and a number of them were for long outstanding cases. Ladies and gentlemen, we have a great team at the Court of Appeal. I must, however, single out the judges. We pride ourselves on being a family. We work hard, but the judges work in addition to their daily exercises. They work nights, they work weekends, they work public holidays in trying to serve the Jamaican people. And I wish to thank them and the court staff for their efforts.
Way in which modern judiciaries operate, and the whole question of the accountability of the judiciary is managed in a different way in comparison to the other arms of government. The other arms of government, they are elected or nominated, depending if you're a senator, and so their accountability comes through not primarily, but not only, through the ballot box, the press, and other means. Where you have an appointed judiciary, the accountability comes in this way. One, through engagements of this nature. Secondly, the publication of statistics, which are on our website, which you can examine at your leisure, and then also in response to questions that persons may ask. The President of the Court of Appeal referred to the whole question of written decisions, or at least a summary of the decisions as to why a particular case was decided in a particular manner. That is also part of the whole question of accountability. And so this is the way that we'll be operating going forward, and it is also one of the important markers identified in the International Framework for Court Excellence, which you can look up on the internet. It's the IFCE, and it sets out their standards for modern judiciaries. And while we mentioned that that is an organization that I had mentioned in 2018 or 19 that would be joining, but we intend to complete that process this year so we can become members of that body. And what that means is that we are indicating to the population at large and to the world at large that these are the standards that we are aspiring to meet. And so that's another way in which we're held accountable. And the whole question of sustainability, because once you achieve a particular target, the question then becomes, how is it sustained? And then this is where now becoming ISO certified, because we are taking steps to become ISO certified in a number of our courts, the Court of Appeal, the Gun Court, the Hanover Parish Court, the St. Thomas Parish Court are the first courts identified to commence that process of ISO certification. And essentially what that involves is the documentation of our processes, and it will be known. So processes relating to just about all aspects of the court's operations. So when you're applying for a spirit license, for those of you who may be interested in earning in that way, it won't be any mystery as to what the process is. You're applying for letters of administration or a grant of probate, no mystery as to what the process is. So all of that will be outlined, and the time standards. And one of the critical things about ISO certification is that you have to subject yourself to an audit annually, and then you're recertified every 3 years. And so those are the ways in which we are improving our operations and holding ourselves accountable. Now, the President spoke of the question of transcripts, and that has been a long-standing problem within the courts. The truth of the matter is that the way in which evidence is recorded in the parish courts and also in the Supreme Court has become a bit dated. That is just the plain truth of the matter. And so this is why now there's a drive to move to a digital recording system. Now that is going to require not just the initial investment in terms of equipment, in terms of training and so on, but also a change in culture. Our courtrooms, oftentimes during trials, sometimes you have the conversation with members of the bar and you have this sort of buzz of conversation in the courtroom. For digital recording to work efficiently and effectively, it means that the courtrooms will become virtually as silent as the grave, because it means that it is essentially, for those of you who are in media and particularly working in a television studio, essentially the court will be a combination of what happens in a studio with what happens in a court. So you can't have too much noise in the court environment, and each microphone will have to have its own channel. You would know far more about this than I do. So that is what will be needed for an effective digital recording system. Means that you have to have a different occupational group. Would be now digital recording clerks. Those posts have been created, and they would have to be trained now to annotate the record. So when an exhibit is being entered, you annotate that. When cross-examination begins, it is marked. So it is both date, time-stamped, and whatever the particular event that is happening in the court, it is captured. So that will now require significant investment in terms of storage and retrieval, and the whole important question of what is the official record of the court for that particular trial. Does it include all the exchanges between the lawyers and the bench? So you may have something arising that not necessarily connected to that particular case, but it may have arisen during a particular case. Does that form part of the record? So those are things that we are working on. We have also developed developing a job description for a new occupational group known as transcriptionists. So these persons will be coming to our courts certainly in the next 12 to 18 months, if not before. And that will go a far way in eliminating this problem of delayed transcripts or unavailable transcripts, because one of the problems that we have had is this. For those of you who have been to the Supreme Court, and you will notice the court reporters are there taking the evidence. If you look at the machine, it's not a typewriter. It has a limited number of keys. And in that discipline, there is no standard way in making a keystroke for a particular word. So let us use where, for example, and you have W-E-A-R, W-A-R-E, W-H-E, W-H-E-R-E, and you have W-E-I-R. So different court reporters can key in any of those words in the way that is comfortable to them. The discipline allows that. And so you find that you have a dictionary, and the dictionary is tied to the machine. So you find this is one of the reasons why court reporter A can't necessarily use the machine for court reporter B and the computer and so on, because it's configured differently. So we have not had a practice of actually producing transcripts as a matter of course. What would happen is that the evidence is taken, and if the person is acquitted, then it isn't turned into a transcript in terms of English characters. It's just there. But somebody may come along 5 years later and say, oh, you know, I need a transcript of the particular trial that took place 5 years ago. By that time, the court reporter may have retired, the court reporter may have migrated, and so it becomes increasingly difficult to produce that transcript. So what is involved here now is sort of changing that, because we still have the court reporters in the system. They won't be replaced, but they are still there, so they are still members of the court family. But we have to change the standards now by which they work, and so produce a transcript as a matter of course, so that in the event that a transcript is needed, it is there. So those are ways and means now of dealing with the question of transcripts, which really means in practical terms that you are going to hear about cases where persons have been convicted in the trial courts, but there are no transcripts for the Court of Appeal, and those appeals will quite likely go down. So just to say that that is likely to happen, certainly in the next few months coming up, but that is a solution now to prevent that happening going forward. And that brings us to the question of the technology in the courts. The President spoke of the JCMS, and that system recently introduced, and it's not a bad system, but there are better systems. So we are looking forward now to another system which we saw in Rwanda, and a similar thing in Spain. And essentially what that is an integrated system in which the major justice actors are connected into it: the police, the prosecution, the courts, and the Department of Corrections. So those were the four main actors on the criminal side. And then you have other persons coming in, such as attorneys, unrepresented persons, and those who need to interact with the court. And one of the advantages of that is, and the attorneys here will tell you that when they come to the civil courts, they hear it quite frequently, Judge, we can't find the file. So when you have an electronic system now, it's fine, that problem is virtually eliminated. So that again means reconfiguring our processes. It may mean practice directions. It may mean altering some aspects of the civil procedure rules to make that happen. So these are ways in which we're going to be using the technology to improve service delivery. And this feeds in now to the question of the role of the Ministry of Justice as it relates to the judiciary. And from my perspective, two of the primary roles of the Ministry of Justice is to provide adequate infrastructure. For those of you who have been down to adequate infrastructure now for the court staff and those who use the court for court purposes, because and I'm very specific in that way, because if you go down to the Supreme Court, you will see a number of our citizens who make excellent use of the court building, but not for the purposes of litigation. They are usually gathered along the Barry Street side of the court, and they gather there late in the evenings from about 6, 7 o'clock, and they enjoy the surroundings right up until the following morning. So that's not what we really have in mind when we talk about using the court and the infrastructure. So something will have to be arrived at in dealing with those of our citizens who are there, because they pose a challenge to attorneys and to court staff when they want to come in to the court building. But it really talking about providing adequate infrastructure to house all the occupational groups. In the past, our courtroom designs were largely based upon the idea that the court is just for the staff and for the judge. But the truth is, a court is also a workspace for attorneys, for police officers, probation officers, and a lot of other persons spend significant hours of the day within the court. A provision will have to be made for that. So we're talking about the whole rethinking and redesigning of our court buildings. We shouldn't have a situation where defendants, witnesses, lawyers are all using the same space, as happens in the Supreme Court when persons are being brought from the cells up into the courtroom, rubbing shoulders with the lawyers, witnesses, jurors. So we have to change all of that. That is why we need modern court buildings to deal with all of those types of issues. And the other thing now is in respect of the case management system and the decision making within the ministry, because we have now gone to Spain about 6 months ago, to Rwanda about 5 months ago, and a definitive decision as to what we are going to do with any of those systems still not yet made. So, and that is now going to require significant outlays of money, certainly in terms of building out the infrastructure for the electronic case management system to operate it. So those are the things that I think the ministry would need to become more proactive in. And the last thing that I'll speak about before I resume my seat is the rethinking circuit courts and how they operate. I think we have to recognize and accept that the 3 or 4 weeks per term, which would work out to about 12 weeks for most of the rural parishes, or 16 weeks, that is definitely insufficient now. In times past, certainly when I spoke to Mr. Phipps many years ago, when he spoke about his time as a prosecutor in the Office of the Director of Public Prosecutions, he said that he would go out and he would go to Manchester, spend about 2 weeks, and you go down to St. Elizabeth, you spend another 2 weeks, and then you go down to Westmoreland. That is how few cases there were at that time. That is definitely not the case now. There used to be parishes where they're known as light circuits, like Trelawney. It's no longer the case. Trelawney has 140 cases. St. Thomas has over 200 cases. So they're no longer light circuits. So the whole question of just 3 weeks and 4 weeks won't work anymore. As to what the configuration is, we'll have to have a discussion about that. And so what I'm really saying then is to, at the very least, we should be looking at major trial centers and taking advantage of the improved road network. So you may have a case, for example, that takes place, let's just say, on the border between, let's say, St. Mary and Portland, right at Dover. For what you might have and it is on the Portland side of the border. But the majority of the witnesses and perhaps the defendant maybe from St. Mary. But as it presently stands, the case would go to Port Antonio. So what you would have is perhaps the witness and the defendant traveling from St. Mary to go to Port Antonio. Now, to get to St. Mary, either the prosecution or the defense would have to make a change of venue application. In the modern world, that shouldn't be so. If it is that most of the persons involved in the case, or all of them, are from the particular parish, then why shouldn't the case be tried there? So those are some of the considerations now that we have to begin to think about in terms of how we deliver legal services.